Good afternoon, everybody. My name is Aaron Dunn, and I'm an attorney at Beresford Booth in the litigation department. Today, I'm going to talk to you about a topic that comes up from time to time in litigation, and a topic that I'm very familiar with, having practiced in the insurance industry before coming to Beresford Booth, and that is reservation of rights letters. Those are letters issued by an insurance company to an insured. Now, you may be thinking, reservation of rights letter, what the heck are you talking about? Heard of discovery, heard of trial, never heard of a letter impacting litigation. It's a fair question. So let me explain. Many people have at least one insurance policy that provides liability coverage. And what that means is coverage that will step in to pay for damages, may pay for damages that a person or business entity may be liable for. So, in other words, instead of paying out of your own pocket, insurance may step in to pay for damages that you become liable for. You can think about car insurance. You hit somebody with your car. Typically, there's liability insurance on an auto policy that will pay for your liability, paying damages that you would otherwise be obligated to pay for. Think about homeowners insurance. Homeowners insurance has liability coverage included. So you damage your neighbor's property, the homeowner's liability insurance may step in. Somebody slips and falls at your house, your homeowner's liability insurance may step in. Think about in the construction context, commercial general liability policies, CGL policies. The contractor performs work at a residence and allegedly causes damage. The CGL liability coverage may step in to pay. Or somebody that's hurt on a construction site, the CGL coverage may come in and pay for damages that the contractor would otherwise be liable for out of their own pocket. So you may be asking, how does a reservation of rights letter come into play? Well, first, a lawsuit's filed. You have a lawsuit filed against you. Somebody alleges that you're liable for damages. Knowing they have liability coverage under one or more policies, you may think, my liability insurance will come in and cover this, or at least should come in and cover this. So what do? You notify your insurance company. You write to your insurance company, say, hey, I have this lawsuit filed against me. I believe there's coverage for this. Please come in, step in, and pay for my defense and make sure that I'm not personally liable if a judgment is rendered against me. Once the insurance company gets the notification from you that there is a lawsuit filed against you, what they're going to do is they're going to evaluate. Now, thinking that a liability insurance policy will automatically cover a claim is not true. Liability insurance is determined by the language of the insurance policy. Every liability insurance policy has conditions, limitations, and most importantly, exclusions that may preclude or limit the insurance company's obligations to pay for any damages that their insured may become liable for. So what does an insurance company do once they get notice of a claim? They use the 8 corners rule. That means the 4 corners of the complaint and the 4 corners of the insurance policy. They look at the allegations made against their insured and the language of the insurance policy, and from there they have to make a determination. Typically, it's pretty easy. In the case of a car accident, you're negligent and you hit somebody. You didn't mean to do it, but you just accidentally hit somebody. The insurance company will look at the allegations. They say negligence, look at the language of the insurance policy. It says they provide coverage for bodily injury or property damage arising from an occurrence or an accident or something along those lines. Pretty easy. They say, check mark. We're going to provide a defense to you by hiring an attorney of our choosing, meaning the insurance company's choosing, to represent you in the lawsuit, and will pay for any damages that you become liable for up to the limit outlined in the insurance policy. It's also pretty easy in other cases where there's definitely no coverage. For example, if you're on a construction site and you're a general contractor, you go up, you're mad at the homeowner or a subcontractor, and you assault them. That's going to be excluded under an intentional acts if no other exclusion is applied, an intentional acts exclusion. So sometimes it's pretty darn easy. But what happens when it's not so clear? Well, that's when we bring in the duty to defend versus the duty to indemnify. Insurers in Washington have a broader duty to defend than a duty to indemnify. That's why the duty to defend you see on your screen is in larger font than the duty to indemnify. Insurance companies have to make a decision. They can either say, we're not providing you with a defense, or we are providing you with a defense. So let's talk about the duty to indemnify versus the duty to defend. Washington courts have said the duty to defend is different from and broader than the duty to indemnify. The duty to indemnify means pay damages that the insured would otherwise be required to pay out of their own pocket. Exists only if the policy actually covers the insured's liability. The duty to defend, on the other hand, is triggered if the insurance policy conceivably covers allegations in the complaint. So you can see the difference here. It's conceivably versus actually covers. So if there's any chance the insurance policy would cover damages that the insured would be liable for, the insurance company has a duty to defend. And that's what we see in the Zia v. ProBuilders case. The court, the Washington Supreme Court, said an insurer must defend a complaint against its insured until it is clear that the claim is not covered. So in sticky situations where the insurance company says, boy, I don't think there is coverage for this claim, but I don't want to breach my duty to defend, don't want to leave my insured hanging out to dry, what am I supposed to do? Well, courts have answered that question. When the allegations in the complaint or the law affecting coverage are unclear, the insurer's proper course of action is to defend under a reservation of rights. So here's how we get to a reservation of rights. The insurance company says, like I mentioned earlier, we don't think there's coverage, but we're not going to face the harsh consequences of breaching our duty to defend. So what do? We're going to defend our insured under a reservation of rights. That means the insurance company is going to hire defense counsel for their insured. It's an attorney of the insurance company's choosing, and then they're going to issue a reservation of rights letter stating why they don't believe insurance coverage exists. So let's talk about the progression of events. Just to recap, we have a lawsuit is filed against the insured. The insured says, oh, I think this claim is covered, notifies their insurance company. The insurance company reviews the allegations in the policy using that 8 corners rule that we talked about. And the insurance company says, this is a sticky situation, but we're going to agree to defend our insured under a reservation of rights, appoint counsel for the insured, and issue our insured a reservation of rights letter. So what's the point of a reservation of rights letter? The purpose of a reservation of rights letter is to identify the insurer's coverage position and serves a dual purpose. Number one, to protect the insured in terms of providing them with a defense, but not guaranteeing that the insurance company will actually cover any damages that the insured becomes liable for. And it allows the insurance company to not face the harsh consequences of refusing to defend their insured. So what does a reservation of rights letter contain? How will you know that you're getting a reservation of rights letter? Well, the insurance company will send you a letter and it'll say something along the lines of reservation of rights. We reserve all our rights. The reservation of rights letter will include language from the insurance policy. It will list the actual language. It'll say, pursuant to your policy with effective dates of X to X, here's the language that we believe is applicable to this claim. It'll list out the coverages that you have and perhaps any exclusions or limitations that the insurance company thinks applies. Then the insurance company will typically include a summary of the allegations against the insured. They'll say, here are the allegations as we understand them. They may not be true, but here's the allegations as we understand them. And then the insurance company will provide a summary of their position regarding coverage. So for example, they'll say, the allegations in the complaint include negligence and assault. We don't believe the assault claim is covered because it's an intentional act. Intentional acts are excluded under the policy, so therefore that portion of the claim is not covered. Or in the commercial general liability context, they may say, yes, there is a negligence allegation, which if true, may be covered, but there are also allegations that if proven would not be covered, such as if it's many CGL policies include a your work or your product exclusion, which are beyond the scope of today's webinar. But they may say, because the allegations implicate, at least according to the insurance company, implicate those exclusions, we're issuing you a reservation of rights saying if those claims, if our coverage position is correct and those claims are not covered, we're not going to indemnify our insured for any damages that are awarded for those allegations. And then finally, the reservation of rights letter typically says something along the lines of, hey, we, the insurance company, may seek a court order confirming that our position regarding coverage is correct. And what they're saying by that is us, the insurance company, we can go file a separate lawsuit, separate from the underlying lawsuit against our insured. We can go file a separate lawsuit saying, hey, court, our coverage position is correct. And even though we're defending our insured under a reservation of rights, just like courts asked us to, we're telling you, court, that our coverage position is correct, so we do not have to indemnify our insured, and we can step away from the defense of our insured. So that's what a reservation of rights letter will typically contain. It'll be obvious to an insured when the reservation of rights letter is issued. So what do you do if you receive a reservation of rights letter? It kind of puts the insured in a precarious position. They say, yeah, the insurance company is providing us with a defense for now anyway, but there's no guarantee that the claim is going to be covered. Are we going to have to pay out of pocket? What should we do? I hear this a lot. So one thing an insured can do is ask the insurance company for additional information. Hey, why did you include these exclusions in your reservation of rights letter? I don't understand how this applies. Could provide the insurance company with additional information. Hey, insurance company, I know that the complaint says X, but here's the real story. And based on the real story, there is coverage. That's an option. Another option is to say, hey, the insurance company is probably correct or may be correct, and we'll have to save some money to prepare to potentially have to pay for a judgment that may not be covered. That's an option, maybe not a great one. And then the third option that I list here on the screen is hire personal counsel. This is an option that I think most attorneys would agree with. Anybody receiving a reservation of rights letter should strongly consider. And why should you strongly consider hiring personal counsel? Well, a couple of reasons. Number one, it allows the attorney to review the reservation of rights letter to evaluate the insurer's coverage position, the strengths and weaknesses of the insurer's position. Often attorneys can review a reservation of rights letter and say, yeah, that exclusion may apply, or no way that exclusion applies. I can write a letter to the insurance company saying, nope, that exclusion is inapplicable per this case or for these reasons. Therefore, remove your reservation of rights letter or amend, or know that we believe this is a bad faith pursuit of a reservation of rights pursuant to that exclusion or that limitation in the policy. Another thing personal counsel can do is coordinate with defense counsel hired by the insurance company to maximize available insurance. By this, I mean working with defense counsel whose client is the insured and to say, hey, defense counsel, you probably know that there's a reservation of rights letter. There are some claims in the complaint that may not be covered. Let's work together on behalf of our joint client to maximize the insurance coverage available and get this resolved for our insured with maximizing the coverage that is available. So you work in coordination because you both have the same goal of protecting the insured, but the insurance companies retain defense counsel. They have, obviously, they're defending the lawsuit, and they want to see that their client gets out on favorable terms by having personal counsel serve as kind of the Batman and Robin, if you will, good guy, bad guy, good cop, bad cop. You can really push the insurance company to settle a claim that they otherwise may fight because of the coverage position. And then the final reason that I list here on the screen is have representation if the insurance company pursues a declaratory judgment action asking another court to confirm their coverage position. So this goes back to what I talked about a couple slides ago, where the insurance company files a separate lawsuit saying, hey, court, confirm our coverage position, agree with us, there is no coverage, and therefore we don't have to provide a defense to our insured and we don't have to indemnify our insured. The insurance defense counsel that the insurance company hires to defend an insured, they will not typically represent the insured in direct action against the insurance company or by the insurance company against the insured regarding coverage. Their sole role is to defend the claims against the insured, whereas personal counsel can come in and say, insurance company, I know you're trying to get out of your obligations pursuant to one or more exclusions or limitations in the policy. However, for numerous reasons, your position is incorrect, and you do have to defend and indemnify the insured. So hiring personal counsel, even though it will cost money out of your own pocket, can save you a lot of money in the long run. So I think most attorneys would agree that hiring personal counsel is a worthwhile endeavor whenever you receive a reservation of rights letter. So if you ever face an issue where you receive a reservation of rights letter, I would highly recommend contacting counsel. The attorneys at Beresford Booth have great experience in this area and would be happy to discuss your specific situation. If you have any questions for me or would like to discuss any particular situation that you're facing, my contact information is on the screen. I'm more than happy to take a call, listen to your issue, and hopefully provide a way to help you out. Thank you very much. I hope you have a great day. Bye-bye.